How is it that Tom Cole never has a hair out of place?
Because he's all right. The Rules Committee will come to order. Before I begin, I want to recognize a former Rules staffer who many of us recognize, Sampak Garg, who's here worked here with Louise for many years, and he's coming back. I think he's nostalgic for all that goes on. Yeah. Well, how long have you been gone now? 12 years. So after 12 years, you begin to miss this. Yeah.
That'll be about the time it takes me to recover.
I was gonna say, the nostalgia will go away quickly.
It was good to see you, Sampak. Welcome back. So today we're considering two measures which seek to protect Americans from unfair forced arbitration and unjust racial discrimination. The first is H.R. 963, the Forced Arbitration and Justice Repeal Act, which prohibits the enforcement of forced arbitration provisions in consumer and employment contracts. For decades, corporate America has used forced arbitration clauses in everything, from cell phone plans to employment contracts. Almost all of us have signed a forced arbitration clause that was tucked into the fine print or buried in the terms and conditions. Once you sign, you waive the right to sue in a court of law, participate in a class action lawsuit, or appeal. You agree that any dispute that arises as a result of buying a product or using a service must be settled by a company's own hand-picked arbitrators. The outcome is shielded from any scrutiny, without a judge, without jury, or the right to appeal. These arbitrators don't have to follow the law or the facts. They don't even have to follow basic notions of fairness or justice. In fact, their only real incentive is to rule in favor of the company so they get repeat business. Does any of that sound fair? Well, it shouldn't. Simply put, these forced arbitration clauses are a get-out-of-jail-free card for corporate America, allowing them to evade responsibility for any harm they cause. Forced arbitration is even becoming common in employment contracts, limiting workers' access to justice. Importantly, this bill does not ban arbitration. It simply gives consumers and workers the choice to arbitrate rather than be forced into it. This is a common-sense piece of legislation that puts government back on the side of the American workers and consumers. The second measure we are considering is H.R. 2116, the Creating a Respectful and Open World for Natural Hair Act, or Crown Act. And frankly, I'm disappointed that this bill needs to come before this committee at all. In the 116th Congress, the Crown Act passed by, the House by voice vote. Last month, we considered this bill under suspension of the rules, and while it received strong bipartisan support, it failed to secure a two-thirds majority to pass. So I hope that this bill passes quickly to demonstrate to the American people that discrimination in any way, shape, or form is wrong. And with that, I'm going to turn now to the distinguished ranking member for any comments that he wishes to make.
Thank you very much, Mr. Chairman. Today's hearing is to take testimony on H.R. 963, the FAIR Act. This bill would retroactively rewrite contracts binding every business and person in the United States to eliminate agreed arbitration provisions. There's one exception, which is, unsurprisingly, for arbitration agreements included in collective bargaining agreements. Arbitration provisions are very common in contracts governing our day-to-day lives, in situations ranging from employment contracts to sales contracts to real estate contracts. They are common for a very good reason. In many, if not most cases, arbitration is easier and cheaper than taking a case through the courts. Yet if the majority has their way, almost all of these provisions would be made illegal and unenforceable. What would be the effect of that? Well, cases that would be previously have been resolved through arbitration would now be forced into litigation. The only real winners in that scenario are trial lawyers, who would obviously stand to benefit from forcing people out of the simple, cheap, and effective arbitration system and into the complex, expensive, and confusing litigation system. But it would be a great loss for business, consumers, workers, and employers. At the end of the day, this is a deeply misguided and even misnamed bill. There's nothing fair about forcing people out of an effective and cheap dispute resolution system and into the courts for the benefit of trial lawyers. This bill would be better called the Trial Lawyers Protection Act, because it is a bill that is written by trial lawyers for the benefit of trial lawyers and at the expense of the American people. Although it's disappointing that we're considering such a misguided piece of legislation, I look forward to hearing from both our witnesses today. With that, Mr. Chairman, I yield back.
Thank you. Thank you very much. The gentleman yields back. I want to welcome our witnesses to provide testimony on H.R. 963, the FAIR Act of 2022. Subcommittee Chairman Johnson, Representative Bishop, we're delighted that you are here. I now recognize the gentleman from Georgia, Subcommittee Chairman Johnson.
Thank you, Mr. Chairman, Ranking Member, for hosting us today. I appear in support of my bipartisan legislation, H.R. 963, the Forced Arbitration and Justice Repeal Act, also known as the FAIR Act, which seeks to restore everyday Americans' Seventh Amendment right to access the court system as the framers of our Constitution intended. When they wrote the preamble to our Constitution, they had certain purposes in mind. The first 20 words of the preamble, we the people of the United States, we the people of the United States, in order to form a more perfect union, establish justice. Establish justice. We the people of the United States, to form a more perfect union, establish justice. So what did they mean when they said establish justice and ensure domestic tranquility thereby? That's why they instituted the Bill of Rights, and in that Bill of Rights, the first 10 amendments, the number 7th amendment, the right to a trial by jury. That's how we would ensure domestic tranquility and establish justice in this country. It'd be through the court system. And they set up 3 co-equal branches of government: the legislative branch, Article 1, Article 2, the executive branch, and Article 3, the judicial branch. 3 co-equal branches serving as a check and balance, one serving as a check and balance on the other. Delicate system of checks and balances to establish justice in this country. That is our pedigree. And when Gretchen Carlson asked for a jury trial after filing a lawsuit accusing Roger Ailes and Fox News of sexual harassment and firing her because she denied his requests for sex, she was met with the bar of a forced arbitration clause that prevented her from taking her matter to court. Same thing happened with Coach Brian Flores just a few weeks ago, filed a lawsuit against the NFL alleging discrimination in hiring and retention and pay. He's met with a forced arbitration clause for a civil rights case that would be diverted into a private for-profit system of so-called justice where the arbitrator is selected by the entity that pays him or her, and a system where there is no dependence on the rule of law. The rules of evidence, rules of procedure don't necessarily apply. There's no right to appeal, no court reporter taking down the proceedings, no oath administered by a judicial officer that requires truthfulness during the hearing. It's just a private for-profit situation set up for businesses, by businesses, conducted by a business. Forced arbitration is a private for-profit business enterprise. That goes against the notions of fair play and justice that our framers intended when they set up a system of ensuring domestic tranquility by establishing justice in the courts. And so what the FAIR Act does is takes us back to a time where everyone had that precious Seventh Amendment right to a trial by jury in front of one's peers, as opposed to being diverted into a private for-profit system that works for the benefit of the business that forced the employer or the consumer to sign away their right to go to court. And so what H.R. 963, the Forced Arbitration and Justice Repeal Act, would do would be to restore the rights of Americans to go to court and seek justice in a court of law. Arbitration clauses have permeated American life in recent decades. They've seeped into our cell phone contracts, our medical paperwork, as well as our employee handbooks. These clauses are hidden in updated terms and conditions, incorporated into mid-year employee reviews, and they are implicit, or actually explicit, in purchase contracts. And they all prevent us from having our day in court. The simple fact is that pre-dispute forced arbitration is a private process that subverts the purpose of the Seventh Amendment by preventing contracting parties from using the American court system when a dispute arises. Certainly nothing wrong with arbitration as a dispute resolution process, but it should be a process chosen by the parties of their own free will after a dispute arises, as opposed to a person being forced to sign such an agreement with a clause that bans their ability to go to court just so that they can get that job or just so that they can make that consumer purchase. That's wrong. The private nature of arbitration leaves us without the ability to hold employers and businesses accountable for wrongdoing. Repeated anti-consumer activity by companies and employers never see the light of day because these secret processes often require secrecy. You can't say anything about it. Those are a part of those agreements that folks sign. This is anti-consumer, anti-employer practices that now permeate our society, and it must change now. When a veteran who is being fired or is fired for being deployed and cannot take their former employer to court because they've signed a forced arbitration clause, something is wrong with the American justice system. When an employee is forced into a private proceeding where their harasser gets to pick the judge, something is wrong with the American system of justice. And when American consumers are forced to sign away their rights when making a purchase, something is wrong with our justice system. The deck has been stacked against everyday Americans in favor of big businesses for far too long. And the pressure on the meek and powerless has only become greater as powerful corporate interests realized that they can avoid accountability by incorporating arbitration clauses into every interaction they have with consumers. President Biden recently signed into law H.R. 4445, the Ending Forced Arbitration of Sexual Harassment and Sexual Assault, protecting the rights of survivors of sexual violence to access the courts. We must continue that work without delay by passing H.R. 963. The FAIR Act would make the system work for everyone the way that the Constitution intended. And I urge this committee to provide an appropriate rule to govern the FAIR Act's consideration, and I urge my colleagues to support this bipartisan legislation. And with that, I'll yield back.
Well, thank you very much. Representative Bishop, we're delighted that you are here.
Thank you, Mr. Chairman, ranking member, members of the committee. This bill intervenes in private contracts to ban informed, competent adults from agreeing on the process they'll use to resolve future disputes. It restricts freedom. it diminishes the freedom of Americans to make contracts. The Democrats seek to demonize arbitration agreements with misleading rhetoric. An arbitration agreement is simply two parties agreeing in advance on the best means of resolving a future dispute between them should one arise, and to make that decision part of the ground rules of their bargain. The bill uses the term forced arbitration, but to the point of the subcommittee chairman, these agreements, these provisions are explicit. They're in the contract that is signed or agreed to. They're not hidden. It just requires reading the contract. There's nothing that forces a person to agree to an arbitration clause that doesn't apply equally to the rest of the contract. And truly forced or involuntary agreements are already illegal under existing law. Democrats want to invalidate pre-dispute arbitration agreements to force more people into court for prolonged battles that serve only the interests of plaintiffs' lawyers, particularly plaintiffs' class action lawyers. They paint agreements to arbitrate as inherently unfair, as if no one would ever willingly agree to use arbitration, but that's simply false. Arbitration is often more efficient and faster than going to court, meaning that injured parties are made whole faster than they would be if they filed a lawsuit. Studies show that plaintiffs in employment and consumer disputes win more often in arbitration and they get more money than they would in court. Even though arbitration may be more attractive than going to court for several reasons, Democrats dismiss those benefits, again, with misleading rhetoric. They say if arbitration is so beneficial, parties can agree to arbitrate after a dispute arises. Of course, that's nearly impossible after tempers have arisen. That's not the time to agree on a dispute resolution process, nor is it the time to evaluate the costs of such a process and how it would affect the bargain the parties have entered into. Once you're in a dispute, you often have legal counsel who have their own motivations with respect to litigating at length. We know that lawyers do have a financial incentive to recommend the most time-consuming, legally complex, and expensive course of action, meaning litigation. By forcing parties to consider arbitration only after a dispute comes up, the bill will effectively take the option to arbitrate off the table. So this will mean more Americans will spend more time in court, pay more in attorney's fees, likely get less money in return. In addition, they'll bog down the court systems, both federal and state, under an extraordinary burden, making the resolution in those forums even lengthier. That's the future for Americans who can afford to go to court with their dispute. And some Americans simply won't be able to afford that litigation. They won't have their claims heard at all. Job creators will feel the effects as well. Because litigation is more expensive, the bill will raise the costs for American small businesses. Employers are already dealing with through-the-roof inflation and a supply chain crisis. This is another distortion of the ability to supply goods and services imposed through federal regulation. With higher litigation costs piled on, they'll have to raise prices and hire fewer employees. Big companies have the cash to hire fancy law firms to defend lawsuits. Smaller businesses that I served in the course of a 30-year litigation career often do not. More lawsuits surely won't help everyday Americans or small businesses, but they will help plaintiffs' lawyers, especially those lawyers who make millions from class action lawsuits. You know, the ones in which consumers get a $5 coupon and the lawyers buy a new jet. It's no surprise that Democrats have been pushing this attack on arbitration agreements for years, particularly recent years in which there have been a series of Supreme Court decisions that specifically limit the ability to bring those class action lawsuits through arbitration. So it's telling that Democrats have consistently, and they do in this bill again, carve out agreements to arbitrate for unions in union contracts. If arbitration is as bad as they say, why is that carve out there? And the bill is not limited to future contracts, contracts that parties will make from this point, from the point this bill is passed onward. It voids millions of contracts that now exist, contracts that are now completely legal and that were entered into on the basis of a bargain that included an arbitration agreement. The economy of the United States is the envy of the world, in significant part because our contract law provides certainty. Our rule of law applied to contracts allows bargainers and deals to plan. And this bill threatens to erode this fundamental feature of our law. No matter what you think about pre-dispute arbitration agreements, everybody should be alarmed when the federal government sets out unilaterally to rewrite private contracts and tell Americans what they cannot agree to. The bill micromanages private relationships and puts the priorities of the plaintiff's bar and union bosses above the interests of hardworking Americans and small businesses. As I said, I practiced law for almost 30 years, representing plaintiffs and defendants in litigation and in arbitration. The first ever appeal that I filed in a case called Benish versus North Carolina Dance Theater was from a trial court decision refusing to enforce an arbitration agreement. A dancer for a professional ballet company sued over the termination of his employment. And this wasn't a wealthy, Amazon-sized corporation oppressing employees, but a fledgling arts organization on a shoestring budget struggling to survive. I worked in that case for free. This bill would have forced that dispute to court and destroyed that arts organization. The bill's overbroad. It's destructive, not only of Americans' freedom, but also of court system dockets. It's an exercise in impracticality, mostly for the sake not of disputes like the one I just made reference to that affect ordinary Americans and small American businesses across the country day in, day out, but mostly for the sake of the plaintiff's class action trial bar. It's a bad bill. And for these reasons, I urge my colleagues to oppose H.R. 963.
Thank you very much. Before I get to my question, I want to yield to the distinguished gentleman from North Carolina, Ms. Ross, who has some guests that she wants to acknowledge.
Well, thank you very much, Mr. Chairman. I just want the committee to know that the North Carolina League of Municipalities and several of our great mayors and council members are here, and Mr. Bishop is also from North Carolina, so I wanted to acknowledge that North Carolina's in the house.
Thank you.
And two of the local elected officials are my constituents, one from Cary and one from Clearwater. Thank you, Mr. Chairman. I yield.
Well, welcome to the Rules Committee. I hope you enjoy it. You may not want to ever come back, but anyway, we're thrilled to have you here. Let me, without objection, I want to ask unanimous consent to insert in the record statements of administration policy in support of both bills that we're talking about here today, H.R. 963 and H.R. 2116. You know, and I'll just say that I appreciate the testimony of both members here today, but, you know, let me just say, I think we can cherry pick the data all we want. I think Americans ought to be free from corporations taking advantage of them. And the bottom line is that millions of Americans, millions of American consumers are unknowingly agreeing to the unfair process of forced arbitration by simply signing up for credit cards, taking out student loans, or using cell phones. And you can say all you want that they should read the fine print. They can go on for pages and pages and pages. But why should the burden be on them? And we know why corporations do this. I mean, my friend likes to paint this as this is all about lawyers. Well, no, it's about consumers. Big corporations do this basically so that they're not held accountable, so they can settle in a way that is always beneficial to them. And doesn't take away anyone's freedom. Mr. Johnson, if I'm correct, I mean, if a consumer chooses, they can choose the route of arbitration. Am I right?
Yeah, if once the dispute arises,
Right.
a consumer, if offered that opportunity by the big business or even small business for that matter, could certainly decide that instead of going through the court process, I'll go through an arbitration process, or they may decide, I like mediation better than arbitration, so let's do it through mediation.
Yeah, right, I mean, and I just don't understand why we have to, why we want to defend, a system where the deck is always stacked against the consumer or the employee. I mean, forced arbitration agreements now are becoming increasingly common in employment contracts. So limiting, access to justice, for workers through the courts. I mean, I'm not somebody who is is a litigious person. But I do know that there are cases when people are treated unfairly. I do know there are cases when people are ripped off. And so, I mean, I think, people ought to have the right to choose whether, as Mr. Chairman Johnson said, I mean, mediation, arbitration, a court of law. I mean, if they can, they should be able to choose what they want. But I mean, this idea that somehow this is not a legitimate concern. I mean, I have constituents all the time, who sign agreements that they don't know forced arbitration is part of it, and are furious when they find out that they have no recourse. This is a deliberate attempt. Let's be honest. This is a deliberate attempt, by mostly big corporations to try to limit recourse for any injustices that they may cause, and to protect their profits. And so to say that everybody knows what they're signing up for, I mean, I don't know, whether everybody reads every fine print in a multi-page document in North Carolina, but I can tell you, in most of the other parts of the country, people sign things regularly, whether it's for their cell phones or for credit cards, and they just do it because they want a credit card. They don't feel like they have to hire a lawyer to be able to interpret what they're signing. So, I mean, I just think, I think most people who might be watching this are saying, like, well, can somebody stick up for us? I know the political rhetoric around here is, oh, this is about big lawyers, big lawyers. No, it's about people who get ripped off, who sign things that, quite frankly, they don't know contains this little clause in it. And so anyway, I think I think we ought to move this forward. I hope that it gets a bipartisan vote on the floor. But again, I thank you both for being here today. Mr. Cole.
Thank you, Mr. Chairman. Mr. Chairman, I ask unanimous consent to insert into the record a statement from Mr. Vince of Oregon in support of his amendment to H.R. 963.
Without objection.
Thank you very much, Mr. Chairman. I just have a few, and let me just say for the record, I'd go into any court with my friend from North Carolina. I know I'd be very well represented. I'd be happy to have him look over any agreement I was signing. But I have a couple of questions for my friend. Mr. Bishop, you mentioned in your testimony the fact that courts can invalidate unlawful arbitration agreements. Can you explain a bit more detail how they're capable of doing this?
I think the gentleman, and arbitration agreements are like any other contract. Contracts require one party to make an offer, the other party to give an acceptance, to exchange consideration between two competent parties. They have to be competent, capable of dealing for their own business. They can be invalidated by common contract defenses. So if someone, I beg your pardon, thank you. If someone engages in fraud, if there's duress, if the contract is unconscionable, all these legal standards that apply, and if it's an unenforceable contract at law, it'll be not enforceable. So a party being tricked into a contract, that contract's not valid. If a party is threatened or coerced, the contract's not valid, including any arbitration provision there is in there. Courts can and do step in and invalidate arbitration agreements when these defenses apply. If an arbitration agreement were truly forced and one party was actually required to agree to it, a court could step in and invalidate the agreement under all usual contract defenses.
Let me also ask you, can you speak, and you touched on this a little bit in your testimony, the benefits of arbitration for consumers?
It's interesting. The chairman used the example of someone buying or being a cell phone or buying a telephone for a cell phone contract, and that if there's an arbitration agreement or clause in the consumer agreement that they'd then be bound by that, and they may not read that. And I don't necessarily disagree with the chairman that there are certain contracts that people won't read. There's a reason they won't read them. To most cell phone customers, whether they're going to arbitrate or litigate some dispute in the future is probably not a big deal. And in fact, the one case that comes to mind is the Supreme Court's decision in AT&T Mobility versus Concepcion, a case from 2011. And what that was about was consumers had gotten a free phone, but the dispute was they had been surprised by the fact they had to pay the sales tax on the phone. So it was $5 or something. And that's true. If the arbitration agreement or clause in that agreement were rendered unenforceable, I don't think that consumer is going to court over the $5. The difference that it makes is the class action trial lawyer that wants to accumulate tens of thousands of those consumers in order to bring a multi-million-dollar claim against AT&T over that issue, and then pocket millions of dollars in fees, and the consumer then gets a coupon for $5. And in order to get that coupon, the consumer has to make sure he fills out the forms and submits them all to the court. And the stats are that, as a practical matter, about 4% of people in big class actions do that. So when you say it's a choice between, for goodness sake, the jury trial right under the Constitution, or being forced into some unfair process, that's a false choice. That's not what's happening.
And Mr. Bishop, how long does it typically take to go through arbitration as compared to litigation?
Depends on the type of the dispute, but there's some concrete numbers. People have studied that in considerable detail. And two categories that are covered by the bill include consumer disputes and employment disputes. In consumer disputes, on average, arbitration took 321 days, while litigation took 439 days. So litigation took about 4 months longer. Employment disputes, on average, arbitration took 659 days, while litigation took 715 days, or about 2 months longer. And I can tell you that from long experience that in either event, it's rare, very rare, about 1 or 2% of cases actually are presented to a jury ultimately. Almost all litigation in court ends in a settlement after some lengthy procedure and the lawyer's fees that come along with it. So it's not really the case. Again, it's a false choice to say that it's between an arbitration way of settling or going to a jury. That's not the way it typically plays out.
And what does that lengthier timeline mean for consumers, especially those with limited financial means and limited time availability?
Well, so particularly consider the example of the cell phone customer with the $5 dispute. He or she is just not going to go to court. Even if it's considerably more than that, they're probably not going to be able to afford lawyers. If they do, consider the fact that arbitration, the Federal Arbitration Act was passed in 1925. Arbitration's been the rule for 100 years for people who choose it in their contracts almost. You take that away, you're going to dump into the existing federal and state court systems an avalanche of additional litigation, which is going to make them all the more backlogged or consume additional resources in order to have disputes pass through. So consumers would have to not only be able to afford a lawyer, but they're going to have longer times to wait for cases to be resolved in court.
And while the bill's entitled the, quote, Forced Arbitration and Justice Repeal Act, doesn't really eliminate, as my friends acknowledged, all arbitration because union contracts were left untouched. What sort of imbalance would this strike between union and non-union employees?
It's a huge imbalance. The Democrats' carve-out for their union friends is just plain wrong. If you're a union, you get to take advantage of all the benefits that arbitration has to offer. You're going to spend less, probably recover more. You're going to resolve the dispute more quickly. You may well have a better chance of winning than if you went to court. All of the benefits we've discussed today attendant to arbitration, unions get them, but not the rest of Americans.
Well, and we're talking about what the relative benefits of this process are. Who benefits more from repeal, the employees themselves or class action attorneys who quite often walk away with the lion's share of the settlement?
Well, that's absolutely it. The lawyers, particularly, and you know, I said as I began that I've been practicing law, litigating cases for an entire career, but I represented people who needed lawyers, and sometimes plaintiffs, sometimes defendant, serving people as effectively, as cost-effectively as possible. But there are a whole lot of lawyers out there in the plaintiff's class action bar that have something far different in mind. Class settlements, as I said, are great for lawyers. They get a huge payday. And they're typically a disappointment for class members who might get a small payment, may get a coupon, as I indicated, that has little value. Expensive lawsuits will drive up the cost of consumer goods. Consider if every contract for cell phone service, you pay $70 or $80 a month for your cell phone service, if the company has to factor in the cost of hundreds of thousands of dollars of litigation expenses to fend off constant class action litigation, where will that cost be absorbed? It'll be absorbed into the cost of the service. So that's on top of exorbitant prices Americans are already struggling with in this terribly inflationary environment. So plaintiffs' lawyers will benefit, plainly, and they'll do so at the expense of hardworking Americans.
Thank you very much. Thank you, Mr. Chairman. Yield back.
Yeah, thank you. And let me just say, I mean, we're all talking about $5 disputes here, as if that's the only issue that might arise. Yeah, there's no question that forced arbitration is easier and cheaper, you know, for Fortune 500 companies in particular. I mean, you get it done quickly, and you can dismiss any dispute that a consumer might have, no matter how legitimate it might be. But I mean, if I did a poll in this hearing room, you know, secret poll, and asked everybody, how many of you actually read the fine print, I mean, in detail, when you sign up for a cell phone or a credit card? I mean, and if you're going to tell me you do, you're weird. But anyway, but I'm just simply saying that, you know, Mrs. O'Leary, who lives in Worcester, Massachusetts, is not reading every single line, and I think, you know, and I think it should be easier for consumers to know what they're getting into, and again, you know, you know, the gentleman is talking about, you know, oh, this old class action suits only in $5 disputes. I mean, that's kind of simplifying the issue in the sense that there are many, many more issues that people may have who feel they were wronged, and in some cases actually deserve, you know, their day in, and I would say they deserve the option of their day in court if in fact they feel they were wronged. So anyway, Mrs. Torres.
Well, I'm not an attorney here, but I know that a process of, after signing an agreement or a clause for arbitration, I mean, what does that process look like for a consumer to go to court? I mean, I think that they would probably have to go through the entire arbitration process. And only if they have a clause that if either party rejects that arbitrator's decision, then they can proceed to court. But it's not automatic. Can you explain, Mr. Chairman,
Yeah.
a little bit about that?
Yeah, thank you for the question, Representative
I'm not the attorney,
Torres.
so feel
Yeah.
free to explain it to me.
Yeah, what happens is a consumer goes in, let's say, to a nursing home to inquire about putting a loved one in a place where they themselves can no longer take care of them, where they can get some professional assistance. They need to be in a nursing home. And if you read the 20-page or 30-page nursing home agreement, embedded in that agreement is a clause that says that you agree to forced arbitration in lieu of going to court if any dispute should arise between us, you and the nursing home company. And then if you don't like that clause in the contract, you can ask them to remove it, and they'll tell you, no, we're not going to remove it. So you go to the next nursing home. You go to all of the nursing homes in your town, and you find that that clause is in every agreement. And so if you want to put your loved one in the nursing home, you're going to have to sign away your right to a jury trial. And that's just the way that it goes. And it's not just for nursing homes, for cell phones, for automobile, to purchase a car, to purchase a home remodeling contracts. When you have any kind of need for a good or service, what we find is that the corporations have put those clauses in the agreement. And so you simply cannot get a good or a service without giving away your Seventh Amendment right to a jury trial. And once you do that, you're bound by the decision of the arbitrator.
I understand that.
There is no going to
But the
court
ranking
after the
member
arbitration
said
proceeding.
that you can, in many cases where I am looking and trying to, Google this, for lack of a better word, and you cannot unless you have a non-binding arbitration agreement.
And there is no
So-
such thing.
And there is no such thing, right. So it is impossible for somebody that has signed this agreement to go directly to court. You cannot.
And that's a great point. Any decision made by the arbitrator cannot be appealed in court.
Right.
And so you're just stuck with a
Unless it's a
decision.
non-binding arbitration agreement, which we know it does not exist, because otherwise, what is the purpose of having this? Thank you for that clarification. I yield back.
Dr. Burgess.
Thank you, Mr. Chairman. Actually, Ranking Member Cole covered most of the ground that I would have asked my friend from North Carolina about. But just to this last point that was just articulated, under current law, as a practical matter right now, can someone be forced? Is there such a thing as forced arbitration?
There's not. The chairman of the subcommittee was describing what would be in the contract, and he said it would say you're going to be forced to go to arbitration. I can tell you, I've looked at arbitration clauses for a long time. None of them say that. There's an agreement to arbitrate. And they make the agreement to arbitrate at the front end. And so that's when the agreement is made. Once the dispute arises, the agreement's enforced. If someone says, well, I don't want to arbitrate at that point, and so they go sue in violation of the agreement that they made, then the court will enforce the arbitration agreement and send the party to arbitration.
And if the results, as far as the party is concerned, are not satisfactory, do they still have the recourse of filing a lawsuit?
They do not as a general proposition, but in certain circumstances they do. If there's a manifest disregard by the law, of the law by the arbitrators that appears in an award, then they can. There are limited grounds on which an appeal is possible. But as a general proposition, the idea is you're going to a place that is faster, doesn't have as many involved rules. You're not going to have discovery and depositions and document requests that go on forever. You're going to be able to pick the time, schedule the time you want to have it resolved instead of whenever it comes up on the court calendar and show up 3 or 4 times till you happen to be called. There are a number of things that are advantageous about arbitration, and if you choose that in your agreement, that's what the nature of contracts is. You make your bargain, and then the bargain is enforced.
I do just have to make a comment about, we've heard a lot about how difficult it is to read the disclaimers and contracts when you sign up for a cell phone or buy a car. But I can't help but feel that a lot of the very verbose and lugubrious language that is in those contracts is a result of things that actually started here. And I don't know if anyone had the experience of buying a house in 2005 and then buying a house in 2017. But I will tell you, having been through that process, it's a lot harder to buy a house today from your community bank because of regulations and requirements and restrictions that Congress passed in the Dodd-Frank Act. And we made this process significantly more onerous. In many cases, I could fail to see where the consumer protection even existed. It was just more language that someone had to pick through and try to understand. So while the corporations may be guilty of several things, I think Congress has to bear some of the responsibility of why these contracts are so onerous and ponderous. But thank you, Mr. Chairman, and I yield back.
Thank you, and I don't want to belabor the point, but when you talk about forced arbitration, I mean, it's kind of like, I think there were like three major cell phone companies in the United States, all have this language. So I guess the deal is you either get your cell phone and sign up for a mandatory arbitration if there's a dispute, or you don't get a cell phone, or you don't get a student loan, or you don't get a credit card. So there's not a lot of choice here. And so when we talk about forced arbitration, I think that's what we're talking about. So yeah, the choice a consumer has is I don't have to sign up for this, or I don't need I'll go without a cell phone. Anyway, Mr. Perlmutter.
Thank you. Just a few questions. Mr. Johnson, do you think if I entered into a contract with Apple, that Apple and I are on equal footing?
Oh, it's.
I do, but do you?
No way that the consumer is in an equal bargaining position with Apple to get an Apple product or an Apple service.
Do you think Mr. Bishop is on equal footing with Facebook when he gets a Facebook account?
In no way is he equal, in my humble opinion.
Do you think when you sign up for Comcast that Ms. Torres is on equal footing with Comcast?
In my humble opinion, she would not be.
And the purpose of the bill that you're presenting, and we've heard this in you before, is because consumers, individuals, employees are not on equal footing. Isn't that the reason we're doing this?
That's correct.
Okay. And Mr. Bishop, you and I have very similar careers, although you've got 5 more years of being a lawyer than me. I did 25 years primarily representing defendants, banks, credit unions, insurance companies, but plaintiff work every now and then, but generally not.
I did more plaintiff work than you.
Okay, well, then you and I were sort of on the opposite sides, and we're on the opposite sides of this issue. Mm-hmm. Because in my opinion, in those cases, in those situations, the company, the business, and primarily the big businesses where there is fear by them that there may be a class action because they have so many customers or they have so many employees that any one person can't take on Apple. Any one person can't take on Facebook. Any one person generally can't take on Comcast. Not to say any of them do anything wrong, but from time to time they make mistakes. You would know that as a lawyer. I know that as a lawyer. So the purpose of this is to allow those individuals to voluntarily either seek the court system pursuant to the 7th Amendment and sort of the approach that we take here in America, or not. And I think, sir, and I'll give you a chance to answer this, I think if we were a tribunal, you proved Mr. Johnson's case. And the reason I think that is you said that if we didn't have this, there would be an avalanche, I think that was your terminology, an avalanche of cases that would go to the courts. Because most people would say, I want somebody who I know is impartial to handle this matter for me. And quite frankly, I believe in the system. You and I have had probably much the same experience. It's been positive, it's been fair, been honest. And that's why, as a lawyer or as a party in a case, I trust those courts. I'll let you respond to that. And then I want to talk to you about unions for 1 second.
Thank you for the opportunity to respond. And I think we might have a different view about the utility, particularly of class action litigation, and what the proportional benefits are to the class counsel versus the claimants, the members of the class, on the whole. But even if you take that aside, and the example that the chairman and you have, and others have cited repeatedly of consumers in cell phone contracts, telecom or cable contracts, all the like. The problem with this bill is that it's a shotgun approach rather than a rifle shot. It doesn't just attend to that issue. It not only does it render unenforceable the arbitration agreement in the case that I talked about, Benish versus North Carolina Dance Theater, with an impecunious, barely thriving, small, very small employer, a new professional arts company that's starting up. I'm so glad that it survived. Members of the North Carolina League of Cities probably are appreciative that that arts community survived all those years ago because of an arbitration provision. But I can give you another example. I've had another case in which I litigated over the validity and enforceability of an arbitration clause in a partnership agreement. So the partnership agreement not only set all the details of how these partners are going to relate to each other for the conduct of their business, it also had employment provisions.
But in
because this bill
something
is so
like
broad,
that, though, let me reclaim my time for a second, and I appreciate your answers. But something like that, there is equal footing, more equal footing certainly than, say, I have with Apple, or he has with Facebook, or she has with Comcast.
right? But the bill outlaws that.
Well, I'm not sure I agree with you, because it talks about employment problems, antitrust problems, consumer problems, and I can't remember what was the fourth thing that.
Antitrust.
Antitrust. So antitrust, like, one of the things we've been talking about, and not we, but the Judiciary Committee has been talking about, is the fact that some of those platforms are so big that if you start working with them, all of a sudden you potentially lose your product. So we're trying to level the playing field on a voluntary basis. We want to talk about freedom on a voluntary basis between the really big guys and those that are much smaller. So I'll end with this, because you questioned the union section of this, the collective bargaining section. And there, I think, again, it's between two co-equals there, the employer and the union. It isn't between the employer and Mrs. McGillicuddy, who, doesn't have nearly the bargaining power that the union would have vis-a-vis the employer. And it says, though, for the individuals, that there is, for the individual worker, they can seek judicial enforcement of any right arising under the Constitution, state constitution, or any federal or state statute or public policy. So they can still bring a claim, but between the union and the business, they're of equal bargaining power, and they have made a contract. And in the old days, back when you and I were practicing, sometimes they called these adhesion contracts, where there is no equal bargaining between, the big company and the individual. So I'll let you respond to that, and then I'll yield back to the chair.
I thank you for that opportunity as well. It's interesting to me that the only situation that is picked out in the statute, in the bill, in situations where there is
You guys got to
equal
watch that
bargaining
table.
power.
You'll end up with the
yeah.
water in your lap.
That was the subcommittee chairman, not me. The only situation you pick out is the union situation, where you believe there'd be relatively equal bargaining power. If you have an employee who is really highly compensated sales employee, earns $750,000 a year, enters into a contract, a commission agreement with an employer, maybe an employer in a textile business, very hard pressed, barely making ends meet. They end up in a dispute with an arbitration provision under this bill. That employer can't make sure that goes to arbitration. They've got to litigate it out. That's my point. Mr. Johnson made reference to the fact that HR 4445 passed a couple of months ago. I'm not sure how long ago now. The Gretchen Carlson situation is signed into law by the president. It was a shock. It was a rifle approach to exempting sexual harassment, sexual assault cases from the effect of binding arbitration. I can understand that. In fact, I voted for it. Most Republicans did. This is different. This is a scattershot, blunderbuss, shotgun approach that kills arbitration in situations where it certainly should occur if parties have agreed to it, including
All right,
many
I'm going to reclaim my time. You've done a good job in responding to my concerns, But for me, this is all about the bargaining position. And Mr. Johnson, you look like you'd like to close, and then I'll yield back to the chair.
Yeah, thank you. You know, there's no reason why an employee who suffers from race discrimination and complains about it should be excluded from going to court, but you allow someone who is claiming sexual assault or sexual harassment to go to court. Why not let all workers be able to take their matter to court and not be bound like Gretchen Carlson was? She made $10 million a year, but she still found that if she wanted to work, she had to sign that agreement. So it was forced arbitration. It was forced upon her. And then when she had a complaint, she found that she couldn't go to court. So she becomes just another employee against a big corporation. No way that she has equal bargaining power to Fox News or even to Roger Ailes for that matter. And so it was totally unfair for her. And what the legislation that passed did was to restore her freedom to be able to go to court as the framers of the Constitution intended. This legislation, the FAIR Act, restores the freedom, the Seventh Amendment freedom that was given to Americans in the Bill of Rights. We gave power to Congress in Article 1, power to the executive in Article 2, power to the judiciary in Article 3, power to the people in the Bill of Rights, 1 through 10. Number 7, the right to a jury trial. It's been taken away. That freedom has been eroded and actually stamped out by a court system that is weighted heavily in favor of corporate interest against consumers and against employees. And so this legislation restores the balance, restores the freedom that Americans once had, once enjoyed, and it restores that freedom to go to court to them. And one last thing I'll say about class actions. We've heard a lot
I
about
think you did a heck of a
class
job. You
actions.
should close where you were.
Well,
Man,
I
that was
gotta-
like great.
I gotta talk about the fact that I'm not sure if my neighbors from North Carolina, well, not quite neighbors, because South Carolina is in between, but I'm not sure if my municipal representatives and county officials that might be here were a part of the recent litigation, class action litigation, against the company that flooded America with opioids. And so they have settled that case, or those cases. These are class action lawsuits that benefit the people of America, a large group of people, when you have a class action. You either win it or you lose it. And if you win it, then the class participants are covered by it and they benefit from it. And usually it works to shut down some kind of unsafe process or practice or product that has been harming the public like these opioids did. And so class actions have a legitimate purpose, but most litigation is just by individuals, just by regular working people of this country, just regular salt of the earth people. Their rights were taken away. We're giving them their freedom and liberty back insofar as the ability to go to court and prosecute their claim when they have been wronged. And with that, I yield back.
Gentlemen, I appreciate your testimony, both of you, and I'll yield back to the chair.
Mr. Rushenthaler.
Thank you, Mr. Chairman. I appreciate it. Mr. Bishop, is there anything you'd like to say in response to the testimony we just heard?
Well, thank you, Mr. Reschenthaler. I was interested in the last comment by Mr. Johnson because, and I was looking as quickly as I could, I believe the litigation against Purdue that he was making reference to, against the Sackler family involving opioids, was a massive lawsuit involving 500 individual cities and counties. It was not class litigation. Class litigation is where 1 or 2 or 3 class representatives are picked. There's class counsel make all the decisions. Those were individual parties. That's not. It doesn't stand in defense of class actions. And class actions are more often those in which the individual would have not enough of a financial stake to bring litigation on their own.
Mr. Bishop, it's my understanding that there's a retroactive nature to this law. Would you like to just explain that?
Right, so it would be, you could pass a law at this point in time that would say, okay, we're going to stop enforcing arbitration agreements in new contracts that you enter into. But this law not only does that, in fact, it says, and by the way, right now, if you enter into an arbitration agreement, the federal arbitration agreement will make it enforceable across the board. This doesn't like withdraw the effect of that and leave it to the states. This says you can't enter into an enforceable agreement to arbitrate. I'm sorry, I lost track of your question in the middle of that. What was the?
No, I was talking about the retroactive nature
Oh,
of
yeah,
this.
yeah. But so the worst part about this is that Americans have been entering into contracts for decades and years that include arbitration provisions, making them a part of the bargain, figuring out how to price services or good predicated on what the rules of the road are going to be. How much litigation cost are we going to bear? And this bill, if passed, would wipe out every one of those contracts that has an arbitration agreement. All those would be rendered unenforceable as well. And that unilaterally for government to step in and rewrite perhaps millions of contracts in the country would be extraordinary and very damaging to the economy.
Right, and that's a legal view on this, but if we just look at the policy view on it, it would really, doing a retroactive bill would really lead to instability, unpredictability in the marketplace, which of course is bad for free markets, correct?
Especially when you're right in the middle of terrible inflation, worst inflation in 40 years. This thing passes and has that impact on the economy, relationships that have already been set up. Already, that's going to force costs up more.
Thanks, Mr. Bishop. I appreciate it. With that, I yield back to the chair.
Thank you, Ms. Scanlon.
Thank you. And of course, Mr. Johnson, we've been discussing this bill for some time in the Judiciary Committee. But it always troubles me that the arbitration clauses, these forced or compulsory arbitration clauses, whatever we call them, are framed as some kind of exercise in free will when we're talking about them in the consumer context. Some sort of idea that we have two parties of equal power agreeing in advance to settle disputes through arbitration, but I don't think that's really fair, and that's what this is about, is fairness to the consumer. If you or I go to purchase a cell phone, sign up for a loan, get cable, are we really able to negotiate the terms of the contract there? I don't think so, and I think we're more likely to be laughed out of the storefront where we're trying to do that. So, there's been also a lot of talk about financial incentives for lawyers to bring cases, and that somehow this puts the thumb on the scale for lawyers. But what about the financial incentives for corporations to include these arbitration clauses? Arbitration clauses where they get to pick the forum for the arbitration and how it runs, and that their in-house lawyers can then enforce for them. There are also the financial disincentives for consumers. It's very difficult for consumers to effectively use arbitration in many cases. And of course, we know that the corporations are saving money by having the arbitration clauses in the first place. So I view this bill as simply rebalancing the scales, taking the thumb off the scale on the side of the corporation. And I guess the last thing just is the pernicious impact of this, that while it is expensive sometimes to have a lawyer, these arbitration clauses, don't they prevent employees or consumers from banding together to share the cost of bringing a claim? Can you speak to that?
Yes, that's exactly right, Representative Scanlon. To go up against a big corporate wrongdoer, billion-dollar international enterprise, been in business for 100 years, just an individual person has a total lack of capacity to go up against such a behemoth by themselves. And so they bind together, put a lot of small cases together, small consumers or employees together, and go against that behemoth and try to have some equality in terms of power. But even then, still being at a severe disadvantage when going to court. As everyone knows, corporations win most of the cases going to court. And it's because they can afford to pay the best lawyers and have like 9 lawyers on one case, and all of those lawyers are making $850 an hour. They're paid by the big corporate behemoth against that consumer. And so that's the way it usually works, but corporations love arbitration because they get to pick the arbitrator and they get to set the rules of the arbitration, and then they refer the cases to the arbitrator, and then the arbitrator rules in their favor even more than happens when folks go to court. And a reason why is because the corporations are paying the arbitrator. And so it's a totally stacked system of justice. With a jury of one's peers, one gets at least a shot at a jury. And it's a fair shot based on the rule of law. But with these corporations in control, arbitration does not work for the consumer. It works for the big business, and that's why they love it so much. And arbitration is basically a take it or leave it situation for the employee or for the worker. If you don't sign, then you don't get the service, or you don't get the job, or you don't get the product. And so it's a take it or leave it situation. That's why we call it forced arbitration.
And that's what kind of negates the whole idea that this is a free will exercise, the freedom to enter into a contract where your only freedom is whether or not you get the good or the service or you don't.
Well, when you need a cell phone, you need a cell phone. When you need a computer, when you need a nursing home, when you need to buy a car or buy a house, you simply don't have the ability to, you don't have any alternative, so you must sign.
Okay. Thank you. I would yield back.
Ms. Fishbach.
Thank you, Mr. Chair. And many of the topics that I was going to ask about have been covered in some of the previous questions, but I will just say that the retroactivity aspect of this bill really concerns me. It really does. When you we pass a bill and eliminate all kinds of contracts that have been signed in good faith, lots has been decided based on those contracts, and so that does bother me. And I also think that the issue of the shotgun approach, as we sit here and Mr. Bishop here exchanged with Mr. Perlmutter, talking about some of those concerns, I think there is a far less broad way to deal with this, a more precise way. If we are trying to level the playing field, there's a better way to do it, because I don't think this will level the playing field. I think in some ways it's going to make it worse, in the sense that now Mr. Johnson mentioned just earlier 9 attorneys sitting at one side, and then you have the consumer. So I don't know if this is really getting at what the supporters are really talking about. And so I'm real concerned, have just strong concerns about this, and I think there's a far better way to do this if this is what we're trying to help consumers. And then just in closing, I just wanted to offer Mr. Bishop the opportunity to comment on anything or anything that you would have to add.
You know, I think that bears emphasis, Ms. Fishbach, that we've demonstrated here in this Congress that we can address a specific problem involving the use of arbitration. And if the problem is big companies, then it begs the question why the bill doesn't address big companies. Now, I think even then, it's easy to forget that the cost environment that you're in, either with respect to existing contracts or contracts going forward for cell phone service, for cable television service, for any number of consumer services, it depends on the circumstances that company's operating in. If you're going to dump, the expectation of class action litigation going on all the time on them, and so that they can't control those costs any longer, you're not going to get your cell phone service at the same price. And so what, and you take millions of Americans maybe don't ever have a conflict with their they know the basic deal on their cell phone. Frankly, if they bought a cell phone and they finance it across the term, maybe 3 years or a year, 18 months or whatever the deal is, and if they decide to leave that early, do we relieve them of that cost because the bargaining power is different? Do you do that in the case of a cable television contract? Are they going to be, can you bind people to any agreement at all if there's a difference in bargaining power? All those things would have to be considered. But even so, if you decide you're going to take on the big guys, and I got no problem doing that. I never represented any of the big guys. It was always little businesses and and people, often against Mr. Perlmutter's clients. But in those circumstances, the notion that that we're going to sit up here in Washington and in an extraordinary departure from common sense are going to say, you can't use arbitration agreements any longer because we're mad at the big guys. That would be the ultimate forgetting of the little people, to me, the regular guys. And I think those are the people we ought to keep in our minds. So I thank you.
And Mr. Bishop, I appreciate that. I agree with you that those are the people we should keep in mind. And just as you were talking, I just have one question. What do you feel, how are you feeling about the constitutionality of changing those contracts retroactively?
I'm uncertain about it, and I'm not an expert on the provisions of the Constitution regarding respecting contracts. It's an area I wish I knew all details about. It came up early. It was coming up earlier, and I was thinking about the retroactivity. I'm not 100% sure it would be constitutional to go and validate all those after the fact, but I can't speak to it, and I have to confess.
Thank you, Mr. Bishop. I'm no expert either. That's why I was asking.
Thanks for exposing something I don't know the answer to.
But thank you, Mr. Bishop, and I yield back. Mr.
Thank
Chair.
you. And again, I just want to emphasize a point I made earlier. This bill doesn't kill arbitration.
Not at all.
All right, so okay. Mr. Morelli.
Thank you, Mr. Chair. I appreciate sponsors' work. I appreciate also Mr. Bishop being here, and I really have enjoyed the conversation. And as one of the non-attorneys here, and this has been really a great conversation. I will say this. I think, and I'd like this stricken for the record. I'm asking that before I even say it, but Ed Perlmutter made really good points here. Particularly, it's first time.
Strike that.
But, that's right, strike what I just said. Thank you. But it really does for me, and because I haven't dealt with these issues as an attorney, but it really does seem to me if you're going to enter into, first of all, if arbitration has significant advantages, and I think people do feel it has advantage in the right place and the right time with the concurrence of both parties. And what I think really is an important point that he made is that it's a question of, is there a balance here? If you or I, Mr. Bishop, entered into some agreement and we decided that we were going to agree to arbitration as opposed to a question of going to trial, so both of us forfeit our rights, and then we're on a level playing field and we have that conversation, I would be more inclined to be supportive of what you're saying. What I fear is, and it's certainly true, I mean, you shrink wrap licenses. If you're going to enter into service, you've basically agreed to something. It's not an informed consent, really. In my prior life, still not an attorney, but in my prior life, I was the chair of the insurance committee in the New York State Assembly. And I remember people saying, well, let's insist on this or insist on that. We'll put it in the print. And you'd end up with an insurance policy that was pages and pages long. And I thought, I'm not sure who's informed here because there's so much. The average person, I don't know if Jim made the point, the chairman, I'm sorry, Mr. Chairman made the point that I think it's not likely that people entering into these, particularly on the consumer side, and you said it's broader than that they're really ever going to spend all the time reading every provision. And oh, by the way, if they got to a provision on arbitration and said, well, I don't like this, so I'm going to scratch it out and sign it and send it back, I think they don't get the service, right? So so I think that's really a compelling point. You're not, forced in the sense that if you want the goods and services, and if all the companies in that space generally put this provision in, then there's clearly no consumer choice in there, and the balance or the imbalance, which other people have articulated, really does, in my mind, call into question the notion of this, particularly since there should be arbitration. The idea of arbitration should appeal to both sides. It shouldn't give one an advantage over the other. The advantage should be it's less costly. It'll perhaps end in a decision more quickly. You don't have to spend the money to have attorneys, et cetera. But if you're compelled to do it, then it says to me, maybe the advantages are all one-sided here in the way that it's done. And I don't know, if I enter into a contract, where does the arbitration take place? It probably doesn't necessarily take place in Rochester, New York. It may take place in Delaware if it's a credit card. It may take place in North Dakota. I don't know what the likelihood is that I'm really going to be able to avail myself of arbitration in the sense that, that we think of it. So I really think that's an issue. I also think I rented a car recently. This is the case in New York. It's the case here in Washington. Get to a point, they say, would you like insurance or not? Do you want to buy the added insurance or do you want yours? This is a yes or no question. Can I have a decision? I can make a decision. And then, by the way, no matter how I answer that, I get to rent the car, right? Either the insurance is on me or I'm buying additional protection. That's a yes or no. I may or may not be informed, but I'm getting the choice. And it doesn't, and the answer to it, how I answer doesn't determine whether or not I'm going to be able to rent the car. So you could have in contracts a yes or no question. Do you want to have arbitration? And I know that we've structured it here, so it's when a dispute arises. Now, do you want to choose? Do you want arbitration or do you want to go and avail yourself of the court system? So I do think for me that's compelling. Even the argument that you made or the example that you made of a salesperson for a large company who's entered into or is in an employment situation and the employer wants to go to arbitration. Doesn't sound to me, and other people have said this, doesn't prohibit you from doing that. You could avail yourself of arbitration, but it's both parties on sort of an equal basis deciding, you know what, let's not go down the road of a court. Let's go to arbitration.
After the dispute arose.
Yeah, no, I understand that, right. I mean, otherwise, if there is an advantage to arbitration versus going to court, and you have to make the decision before the dispute even arises, I mean, that limits your choices to be able to do it. So I'm certainly not opposed to arbitration, but I think the way it's done here, it makes it sound like, oh, you entered into it. I think Ms. Fischbach said you signed in good faith. I don't know, was it in good faith? You didn't really have you weren't involved in the decision at all. It's not like you ever had a conversation. It's not like no matter who you go to that they said, well, here's an idea. Why don't we, even beforehand, Mr. Johnson, but you don't even get that, right? They're not saying before the dispute. They're saying before the dispute, and by the way, you're going to sign this or not. So I appreciate the conversation. I think it's been really interesting, and I would say this too. You may, Mr. Bishop, think it's too broad. I could accept it, and that's a legitimate argument to have, but I would say if the question is it do we draft it really narrowly or too broadly, I think I'd opt to more broadly because it preserves more rights. Maybe you and Mr. Johnson would come up with a compromise that's more narrow but still fulfills all the needs. And honestly, the last point I'd say, and I'll admit I'm way outside of my area of expertise, but it sounds to me at times like you're suggesting this should be a shield against class action litigation. I agree society can be too litigious, but is this really what we want? I mean, where there's a class that's been harmed, do we want to give people a shield so that makes it more difficult for legitimate classes to advance and you put a barrier in front of them? I'm not even sure I like that argument because I'm not sure how that protects anyone. And at the end of the day, this is what we should all want, right? We want both parties to a dispute to have access to what is justice. Mr. Johnson used the phrase. I think it's exactly what our system ought to be about. I think you could achieve justice through arbitration, but not if one party says as a default, we're going to insist on it long before a dispute even arises. We want you to basically give away your rights to the court system, the justice system. So anyway, I appreciate all the arguments. I think this has really been thoughtful on all sides, and I'll support the rule and the underlying bill, and with that, I'll yield back.
Mr. DeSaulnier? Ms. Ross?
Thank you, Mr. Chairman, and thank you for welcoming the folks from North Carolina. I will remind this committee that Mr. Bishop and I were in the same law school class, and many of our colleagues are amused that we're both here in Congress at the same time.
We're having the same old arguments, too.
Having the same old arguments. Oh, I think I got better grades. But too often, forced arbitration clauses require individuals to settle disputes according to rules and procedures that are created to give an advantage to corporate interests, while limiting the opportunities to hold these corporations accountable. And I think we've been talking a lot about these individual claims, but some of the things that have to go to arbitration are serious, big issues of the day. The opioid issue is a perfect example. Civil rights violations, other examples. Consumer protection issues, other examples. And when companies can use mandatory arbitration clauses to cover up claims for employment discrimination, consumer safety, civil rights violations, then not only is it depriving people of their ability to go to court, but it's depriving the public of the ability to know when we have bad actors out there. And it's exacerbated by the fact that arbitration agreements are often combined with non-disclosure agreements and bans on class actions. This would deny consumers and employees the opportunity to come together and challenge misconduct in a court of law and have the public know that and deter these practices in the future. Because if you can just arbitrate them one after the other, there is absolutely no incentive to change the behavior. There is no incentive to have safer products. There is no incentive to stop civil rights violations. There is no incentive to stop discrimination based on gender, on sexual orientation, on race, all of these things. And it's clear that this current system doesn't work for people who need protection. When the arbitration process is used to preserve the power of companies, rather than to provide due process to employees facing mistreatment and consumers who are harmed, we have a duty to step in. Our laws should work to curb practices that enable the abuse of consumers and the abuse of individuals in the workplace. I support the underlying bill and the rule, and I did in the Judiciary Committee, but I also wanted to ask Mr. Johnson, because I read that he has an additional person supporting this bill lately, Mr. Flores, against the NFL. So could you tell me a little bit more about Brian Flores and his position on the FAIR Act and how he sees having forced arbitration as a way to just keep bad practices within the NFL going on?
Thank you, Representative Ross. Brian Flores was the coach of the Miami Dolphins, and he had, I think, a 9-8 season, a winning season, and he was let go by the club. And he was let go after he alleges that he was asked to not win so much so that they could have a better chance in draft selection for next year. And he declined to do that. We know that players, a player for Atlanta was just suspended indefinitely for gambling. And that's what this is pretty much. When you ask a man to shave off points or don't win so that we can have a better chance at getting a high draft selection next year, that's what he refused to do. And for that act, he was fired. And he happens to be, I think, he happened to be one of two then coaches in the NFL. I think 28 teams, I may be mistaken, but 70% of the players in the NFL black, only 2 head coaches black. Now it's only 1. And he filed a lawsuit saying that he was fired and he was mistreated after going to another team that, in compliance with the Rooney Rule, interviewed him for the vacant job, but yet they had already made a decision to hire somebody else, and they were just going through the motions by interviewing a black coach. And so he was denied that job after being fired, and so he filed litigation against the NFL and against the respective teams, alleging that he was the victim of racial discrimination in hiring, in pay, and in retention. And what happened then was the NFL raised this nasty little clause, this nasty little forced arbitration clause that he had signed when he became a head coach. Something that he had wanted to do for, since he was a young boy. He wanted to be a coach in the NFL. And he finally worked hard, paid his dues, got to the point where he got the job, and he was not going to walk away from the job because of a arbitration clause in the agreement. So he signed the agreement. It was a forced situation. And now the NFL seeks to quiet this matter. They don't want you to know about the racial discrimination. They don't want any discovery. They don't want any compliance with the rules of procedure and evidence that would be in place to help people get to the truth. They don't want that. They want to steer it into the private, for-profit dispute resolution process called arbitration, which they set up. And so Coach Flores is very much in favor of this legislation, the FAIR Act. He wants to see it passed because people like him who are alleging racial discrimination can't go to court. I'm glad that Gretchen Carlson fought so hard, and based on her work and the work of my friend Representative Sherry Bustos, who sponsored the legislation, they got that legislation passed, and President Biden signed it into law, and I was there when he signed it. It was a proud moment for men and women alike. But now we've got to go further and protect other employees and also protect consumers who all of them are treated unfairly based on their signing of these forced arbitration clauses.
Thank you, Mr. Chairman. I yield back, but clearly the one bill was good, but the second bill just finishes the job.
Thank you. I'm happy to yield to Mr. Neguse. How you feeling?
Thank you, Mr. Chairman. Well, I've concluded that if there's anything that will kill COVID, it is a 2-hour debate in the Rules Committee.
You're cured. You're cured. It's a miracle.
Feeling much better after today's debate. I, of course, support the bill. I appreciate the conversation. I think it's been a very rich and robust debate on both sides of the aisle. I just want to follow up on something that Mr. Morelli said in reference to Mr. Perlmutter, and perhaps Mr. Bishop, you could respond. I guess I'm trying to get a better sense of, is it your position that if this bill were to become law, that arbitration would no longer be a process that's utilized by plaintiffs and defendants alike, by employers or by employees, or the remainder?
I think, Mr. Neguse, that some people will continue to use it, but there's going to be an evaluation whether somebody gets a tactical advantage after the dispute arises in ways that may or may not revolve around the merits. Mr. Johnson was just speaking of the Flores case. I don't know anything about the Flores case. It strikes me as unlikely that an NFL coach didn't have any bargaining power. And the charges that he's making are sensational. And they may be true. But they may be charges that are concocted, or at least in another situation. Let's take it away from Brian Flores and make it just another hypothetical situation. Maybe he sees the opportunity to gain an advantage by making sensational allegations that are false in public. And does that mean that the agreement to arbitrate in advance was a bad agreement? Maybe it was quite fair. and the unfairness is the person who seeks to get rid of the bargain after the fact.
Yeah, I guess I appreciate that, Mr. Bishop. I think the point that I'm trying to kind of glean here is the point that Representative Perlmutter was making at the outset of the hearing, which is to say that to the extent we believe that arbitration will no longer be utilized by, litigants more broadly, if this bill were to become law, it in effect is a concession that the system, is so flawed that no one seeking a fair chance of justice would ultimately make the voluntary choice to pursue arbitration post dispute. And so I support the bill. I appreciate Chairman Johnson, your leadership year after year, session after session in pushing this forward. I think the notion that if this bill were to become law, that somehow it's going to impact or have broader cost collateral consequences within the market is just not sustained by the facts, right? Clearly, the 1925 Federal Arbitration Act, it's been on the books for quite some time. The proliferation of arbitration, of forced arbitration, is a fairly recent phenomenon. And I practiced law for many years in Colorado before I was elected to Congress, representing plaintiffs and defendants, including some arbitrations. We know that it's the series of decisions made by the Supreme Court over the course of the last 30 years or so that have essentially enabled arbitration, forced arbitration, to become the forum of choice for big corporations, right? So, it's not, employment disputes weren't subject to forced arbitration before 20 years ago. And it's not as though, in the past, I don't think our commercial contracts suffered simply because forced arbitration wasn't an option. So I think this bill makes a lot of sense and proud to support it and the rule. With that, I yield back.
Thank you very much. Appreciate it. Is there anyone else who wishes to testify on H.R. 963? Mr. Cole.
Just wanted to make a quick comment. Just after looking at and listening to our friend, Mr. Neguse, I think he has a false negative test. That's an amazing performance, so it's good to see my friend look so well in such difficult circumstances.
Hey, thank you, Mr. Cole.
So seeing nobody else that wants to ask questions, this closes the hearing on H.R. 963. You are all free to go.
Thank you.
Thank you. Yeah.
Thank you.
At this time, the chair will entertain a motion from the distinguished gentlewoman from California, Mrs. Torres.
Thank you very much. I know I've got that balancing that.
Mr. Chairman, I move the committee grant H.R. 963, the FAIR Act of 2022, a structure rule. The rule provides 1 hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary or their designees. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 117-34 shall be considered as adopted and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule makes in order the amendment printed in the Rules Committee report if offered by the member designated in the report, which shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendment printed in the report. The rule provides 1 motion to recommit. The rule further provides the consideration of H.R. 2116, the Crown Act of 2021, under a closed rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary or their designees. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 117-36 shall be considered as adopted and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides 1 motion to recommit.
You heard the motion from the gentlewoman from California. Is there any amendment or discussion? Before I yield to Mr. Cole, let me just say the Republicans got all the amendments.
All?
All the amendments that are in order.
Well, we have an oldie but goodie that I doubt you considered, Mr. Chairman, but I want to bring to your attention again. I have an amendment to the rule. I move the committee add language in the rule to stop the tolling of days for the resolution of inquiry. That would be in order. Mr. Chairman, when the Rules Committee first held our hearing and markup on House Resolution 965 on May 14th of 2020, almost 2 years ago, Majority Leader Hoyer testified at that meeting, and he said, quote, "All the rules that apply for the minority protections apply, and they should. This is not about getting advantage. This is about allowing the people's house and the people's representatives in committee to work and work productively," unquote. You know, Mr. Chairman, included in the language of the rule providing for consideration proxy voting, which turned off the ability of members, including the minority and the majority, I might add, to offer resolutions of inquiry, directly contradicts the majority leader's promise. So to that end, I urge that we repeal provisions which effectively neuter the use of resolutions of inquiry and no longer use COVID as an excuse to the advantage of the majority, and frankly, to the disadvantage, I think, of every single member of the House. Again, this is a tool that's used by both sides, particularly the minority, but used by both sides. It's not out there now, and we would like to see it restored, particularly in these circumstances where we're operating somewhat more closely to normal than we were, obviously, 2 years ago.
Thank you. Do you want me to respond, or should we just move on?
I'm always enlightened by your views, but if you want to, in the expedite matters, I understand that as well.
Yeah, because I think I would go on a little bit long today, given kind of the pattern that I think is we're seeing develop on the House floor of endless roll call votes that are totally unnecessary, oftentimes against what the Republican leadership does. And I think there is a concern, as I've said many times before, that we have some members here who are not interested in investigations, but are interested in disruption and delay at a time when we're still coming out of COVID. And I would just say, with respect, that if people are interested in investigations, I would hope that somebody could communicate to the minority leader that he should investigate, he should cooperate with the investigation being conducted by the January 6th committee, in which this Capitol was attacked and people died and 140 Capitol police officers were injured. So I will, at this point, urge a
Respond very
absolutely.
quickly. Well, I think as you remove the legitimate tools of the minority, like motions to recommit, like the tolling of days, then I think you get more of these things on the floor. Again, when you shut down the ability of people to respond, I think they resort to whatever tactics you leave them. And, unfortunately, I think you haven't left them much. So
Well,
that's my view, and I wish we would get back to normal in these very legitimate tools, again, which my friends used appropriately when they were in the minority and, pre-COVID allowed, and I just think there's no reason for them not to come back. But again, Mr. Chairman.
Well, I mean, I think what happened on Wednesday was that a group of your members were upset that you didn't call for a roll call vote on the continuing resolution and had a meltdown, and unfortunately kept the support staff here beyond the time they should have been here, which I think is a terrible, inconsiderate thing to do. I'm not saying you on this, who are in this committee, but I mean, I think there's a lot of kind of concern about what really is behind all of this. And I think if it was the people on this committee that we were dealing with, I would have no problem being a fierce advocate for what you are saying at this particular time. But I am now beginning to wonder what the agenda of some of the people in this chamber are. So look, I mean, hopefully we will continue to have these discussions, but it would be a lot easier if some of the tactics that were happening for no definable reason that I can see, other than just a delay and cause inconvenience, and I don't mind being here forever, but I do really resent, and I know the gentleman does too, that some of our staff, but the support staff, the people who make sure that this house runs, had to stay as long as they did because somebody had a tantrum. And I just don't have any, I've lost my patience for that. But anyway, anybody else want to say anything? Yeah, Ms. Fishbach.
And Mr. Chair, I guess it's kind of a question, and when we were talking about one of the motions in particular, I believe it was the majority that kept the motion to adjourn open for 7 or 8 hours. I can't remember exactly. I mean, it was significant amount of time. So I guess that added significantly to the delay.
And I would point out to the gentlelady, that was, at least that was in the daytime, but keeping people here into the wee hours of the night, I mean,
Well,
I'll be honest with you, I think that is beyond the pale.
well, and Mr.
And
Chair,
you know
I
what?
appreciate, but if that had been open
well,
for
I
15
mean,
minutes, we would have gotten things done quicker.
Yeah, and as you know, we were working through legislative language in order to make sure that we could pass an omnibus appropriations bill to keep this government running. So that is a little bit different, in my opinion, than having a meltdown because people on your side didn't call for a roll call vote on a continuing resolution. So I don't know. I mean, we can talk about this all you want. I'll just tell you, I think people are just kind of fed up with it, and I think people are also, I think people are also questioning what the motives are behind, not you, but why people would like to have the opportunity to disrupt even more. People want us to get things done, and we're able to do it in spite of the disruptions.
May I just quickly respond, Mr. Chairman? First of all, I appreciate you excluding.
I do.
I know you do. We've had this discussion privately. But to Ms. Fishbach's point, look, we were here late at night because we were here all day. That wasn't on our side. That was on your side. And by the way, that's using the procedures of the House to disrupt the House. That's exactly what happened. Your side chose not to pass the rule, dozens of your members. And that's why we were here late at night. Now, I voted for, the continuing resolution. I was in favor, honestly, of both.
What was the voice vote?
Bills we had, yeah. But, well, I would have voted
Yeah,
for it. And I think I made that clear in my comments on the floor at the time. But this idea that one side disrupts the House and the other doesn't, look, the majority can disrupt the House just as much. And when you clamp down on the minority, number one, you don't leave them very many tools. And number two, at the end of the day, it was you guys that kept us here all day, not us.
With
So
respect,
let's just make that clear.
with
for the record.
respect, we would have been.
Worried about the staff, then your side shouldn't have brought down the rule or threatened to bring down the rule.
But with respect, we would have been out at a decent hour had it not been for the delay text. And by the way, the protest on your side was to your leadership, I was told by the disruptors, and not to our leadership.
I would assume the protest on your side was to your leadership.
It was.
We didn't write the bill, you
Right,
did.
but, yeah. And then the other thing is, again, if we're serious about investigations, please tell the minority leader that he should cooperate with the bipartisan committee
Perhaps
to
if
actually
the
look at.
speaker had followed tradition and let him appoint his own members to the committee, instead of unilaterally taking that away from him,
Well,
he might be more
Yeah, well,
disposed to do that.
Perhaps
But,
if he had kept what we all thought was his word, that in fact a truly bipartisan commission would be accepted, we wouldn't be having this conversation, but he chose another path.
We've gotten our
So, in any
amendments to
event,
that rule
yeah.
accepted, you
All
might
right.
have gotten that.
So the question is now on the motion of the, on the amendment by the gentleman from Oklahoma. All those in favor say aye.
Aye.
Opposed, say no. No. Opinion of the chair, the noes have it.
And then I request a recorded
Recorded
vote.
vote has been requested.
Mrs. Torres. Mrs. Torres, no. Mr. Perlmutter. Mr. Perlmutter, no. Mr. Raskin. Ms. Scanlon. Ms. Scanlon, no. Mr. Morelli. Mr. Morelli, no. Mr. DeSaulnier.
No.
Mr. DeSaulnier, no. Ms. Ross.
No.
Ms. Ross, no. Mr. Neguse.
No.
Mr. Neguse, no. Mr. Cole.
Aye.
Mr. Cole, aye. Mr. Burgess. Mr. Burgess, aye. Mr. Reschenthaler. Mr. Reschenthaler, aye. Mrs. Fishbach. Mrs. Fishbach, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk, report the total.
4 yeas, 8 nays.
Not agreed to. Further amendments. Mr. Cole.
Thank you very much, Mr. Chairman. Mr. Chairman, I have an amendment to the rule. I move that the committee make an order amendment number 5 to H.R. 963, offered by Mr. Fitzgerald of Wisconsin. The amendment would help employers in some of the industries most affected by the president's economic policies by exempting them from this bill. That's the least we can do for American businesses and American people that they serve. The bill would place new and unnecessary costs on American businesses and ultimately on Americans at a time when they're already reeling from the administration's failing economic policy. Inflation is already at the highest level in years. Millions of Americans who were employed before the pandemic still have not rejoined the workforce. There's a worker shortage in the United States, and now we're seeing supply chain problems causing shortages across the country. So these types of challenges and others, frankly, driven by the administration's policies, and, you know, we think that matters because individual Americans ultimately shoulder the cost for these policies. So the bill adds to these challenges and further burdens Americans by racing to rewrite millions of agreements. It also makes running a business even more costly in ways that primarily benefit trial lawyers. So I urge the adoption of my motion and yield back.
Heard the gentleman's amendment. Any discussion? If not, the vote is on the Cole Amendment. All those in favor say aye.
Aye.
Opposed, no. No. Being the chair, the noes have it.
And, Mr. Chairman,
Roll call
now
vote has
I
been
request a
requested.
roll call.
Mrs. Torres? Mrs. Torres, no. Mr. Perlmutter? No. Mr. Perlmutter, no. Mr. Raskin? Ms. Scanlon? No. Ms. Scanlon, no. Mr. Morelli? No. Mr. Morelli, no. Mr. DeSaulnier?
No.
Mr. DeSaulnier, no. Ms. Ross? No. Ms. Ross, no. Mr. Neguse?
No.
Mr. Neguse, no. Mr. Cole?
Aye.
Mr. Cole, aye. Mr. Burgess? Aye. Mr. Burgess, aye. Mr. Reshenthaler? Aye. Mr. Reshenthaler, aye. Mrs. Fishbach? Aye. Mrs. Fishbach, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk, report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Further amendments. Dr. Burgess.
Mr. Chairman, I have an amendment to the rule. I move to add a section to the rule which would repeal Section 4 of House Resolution 508. Section 4 of House Resolution 508 turned off the expedited procedures for considering a joint resolution to terminate the national emergency declared by President Trump on March 13, 2020. The nation, fortunately, is beginning to see the coronavirus in our rearview mirror. Public health restrictions are being lifted around the country, including this institution. The National Emergencies Act allows Congress to terminate, with a joint resolution, a national emergency declared by the President. We should not be voluntarily restricting our own Article I power by turning off this important capability. Congressional members must be able to make the best decisions on behalf of the districts and constituents they represent. Turning off the ability to legislate on behalf of the American people because one party is afraid of the outcome of such a vote is not good governance and not good for the country.
Heard the gentleman's amendment. Any discussion? If not, the vote is on the Burgess Amendment. All those in favor say aye.
Aye.
Opposed, no. No. Being the chair, the noes have it.
Ask for a roll call.
Roll call has been requested.
Mrs. Torres? Mrs. Torres, no. Mr. Perlmutter? Mr. Perlmutter, no. Mr. Raskin? Ms. Scanlon? No. Ms. Scanlon, no. Mr. Morelli? Mr. Morelli, no. Mr. DeSaulnier?
No.
Mr. DeSaulnier, no. Ms. Ross? No. Ms. Ross, no. Mr. Neguse?
No.
Mr. Neguse, no. Mr. Cole? Aye. Mr. Cole, aye. Mr. Burgess?
Aye.
Mr. Burgess, aye. Mr. Reshenthaler? Aye. Mr. Reshenthaler, aye. Mrs. Fishbach? Aye. Mrs. Fishbach, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk, report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Further amendments. Mr. Reshenthaler.
Thank you, Mr. Chairman. I have an amendment to the rule. I move the committee make an order amendment number 1 to H.R. 963, which is offered by Mr. Bentz of Oregon. This amendment strikes a sentence on page number 7 that would invite legal challenges to millions of existing contracts by retroactively applying the provisions of this bill. Applying new laws retroactively undermines the rule of law and prevents contracting parties from having certainty about their contracts. This amendment would apply to the provisions of H.R. 963 only to agreements entered into after the bill goes into effect and avoid the inherent unfairness of Congress directly interfering with existing contracts and agreements. So I urge adoption of my motion, and I yield back.
Heard the gentleman's amendment. Any discussion? If not, the vote is on the Reshenthaler Amendment. All those in favor say aye. Aye. Opposed, no. No. Being the chair, the noes have it.
Mr. Chairman, on that I request the yeas and nays.
Yeas and nays have been requested.
Mrs. Torres?
No.
Mrs. Torres, no. Mr. Perlmutter? No. Mr. Perlmutter, no. Mr. Raskin? Ms. Scanlon? No. Ms. Scanlon, no. Mr. Morelli? Mr. Morelli, no. Mr. DeSaulnier?
No.
Mr. DeSaulnier, no. Ms. Ross? No. Ms. Ross, no. Mr. Neguse?
No.
Mr. Neguse, no. Mr. Cole? Aye. Mr. Cole, aye. Mr. Burgess? Aye. Mr. Burgess, aye. Mr. Reschenthaler? Aye. Mr. Reschenthaler, aye. Mrs. Fishbach? Aye. Mrs. Fishbach, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk, report the total.
4 yeas, 8 nays.
Members not agreed to further amendments. Ms. Fishbach?
And Mr. Chair, just before I offer the amendment, I'm just kind of curious, I have not been able to see Mr. Neguse on my screen. I don't know if someone else is.
Yeah,
Okay,
yeah.
all right. That's all I'm asking is because I understand the rule
Well,
requires.
yeah, and Mr. Cole said he looks fabulous.
Oh,
yeah.
no, earlier, but when he's voting, I'm unable to see him.
okay, yeah.
I've seen him earlier, but I'm fine with that then as long as someone's seeing him. But thank you, Mr. Chair. I have an amendment to the rule. I move that the committee make an order amendment number 3 to H.R. 963 offered by Mr. Fitzgerald of Wisconsin. This bill, as written, advances the interests of the plaintiffs' bar, not employees, by eliminating arbitration for a wide variety of disputes. Arbitration can empower workers, allowing them to vindicate their claims without the need to convince an attorney to take the case, which typically requires turning over to the lawyer a big share of the recovery. Amendment number 3 requires that the amount of recoverable attorney's fees not exceed a reasonable percentage of a victim's direct recovery, and that in no event can the lawyer receive more money than the employee. This provision addresses the reality that attorneys are often incentivized to oppose efficient and fair resolution of employee claims and to particularly oppose arbitration, because more efficient and less costly resolution of claims usually results in lower legal fees. This incentive unfortunately exists even when protracted litigation delivers no further benefit to the employee. I urge adoption of my motion to ensure consumers are not taken advantage of by predatory trial lawyers, and I yield back.
You heard the gentlewoman's amendment. Any discussion? If not, the vote is on the Fishbach amendment. Those in favor say aye. Aye. Opposed, no. No. Any of the chair, the noes have it. Yeas and nays have been requested.
Mrs. Torres?
No.
Mrs. Torres, no. Mr. Perlmutter? No. Mr. Perlmutter, no. Mr. Raskin? Ms. Scanlon? No. Ms. Scanlon, no. Mr. Morelli? No. Mr. Morelli, no. Mr. DeSaulnier?
No.
Mr. DeSaulnier, no. Ms. Ross? No. Ms. Ross, no. Mr. Neguse?
No.
Mr. Neguse, no. Mr. Cole? Aye. Mr. Cole, aye. Mr. Burgess? Mr. Burgess, aye. Mr. Reschenthaler? Mr. Reschenthaler, aye. Mrs. Fishbach? Aye. Mrs. Fishbach, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk, report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Are there further amendments? If not, the vote is on the motion from the gentleman from California. All those in favor say aye. Aye. Opposed, no. No. Being the chair, the ayes have it.
Mr. Chairman, on that question.
A recorded vote has been requested. Clerk will call the roll.
Mrs. Torres?
Aye.
Mrs. Torres, aye. Mr. Perlmutter? Aye. Mr. Perlmutter, aye. Mr. Raskin? Ms. Scanlon? Ms. Scanlon, aye. Mr. Morelli? Mr. Morelli, aye. Mr. DeSaulnier?
Aye.
Mr. DeSaulnier, aye. Ms. Ross? Aye. Ms. Ross, aye. Mr. Neguse?
Aye.
Mr. Neguse, aye. Mr. Cole? No. Mr. Cole, no. Mr. Burgess? No. Mr. Burgess, no. Mr. Reschenthaler? Yeah. Mr. Reschenthaler, no. Mrs. Fishbach? No. Mrs. Fishbach, no. Mr. Chairman?
Aye.
Mr. Chairman, aye.
Clerk, report the total.
8 yeas, 4 nays.
Motion is agreed to, and Mrs. Torres will carry it for the Democrats. Ms. Fishbach will carry it for the Republicans. Thank you very much. Without objection, the committee is adjourned.
It's Betsy DeSaulnier voting. Mark,